I so enjoy this speaker because he's always great. Ovid is running around New York going to graduations. Apparently a bunch of his kids are graduating all at the same time. So he's going from one graduation to another. But he promised he'd be back next meeting. Now I'm going to ask you to reach into your pockets and your pocketbooks and turn the bloomin' things off. And you know what I'm talking about. Our next meeting will be June, my gosh, where'd the year go? June the 2nd with Maggie Winter, and she's right now running around Scotland, God love her. And she's going to be speaking about the Constitutional Convention. And we've done nothing but talk about the Constitution. Well, what did those guys go through to create this thing? And she's going to talk about how there were deep political divisions among the people who wrote this. Hello? What was that? It sounded like I was in synagogue and it was the, oh well. And she's going to give us an idea and a picture of what these men went through to create what we are now fussing about. So you don't want to miss it. It's June the 2nd, here, as you know. This was one of the weirdest researches about what happened on this date through the years. And you'll see as I tell you about it. All right, in 1535, the French explorer Jacques Cartier left France for the second voyage, and he found Newfoundland. In 1536, Anne Boleyn, second wife of Henry VIII, was beheaded for charges of adultery, incest, and treason. In 1749, the British King George II of England granted charter to the Ohio Company to settle in the Ohio Valley in America. In 1828, U.S. President John Quincy Adams signed the Tariff of 1828, the Tariff of Abominations. We like that title, maybe? Into law to protect the industry in the North. In 1857, American William Francis Channing and Moses Farmer patented the electric fire alarm. In 1883, William Cody held the first of his Buffalo Bills Wild West shows in Omaha, Nebraska. In 1884, Ringling Brothers Circus premiered in Baraboo, Wisconsin. In 1885, the first mass production of shoes took place in Lynn, Massachusetts. In 1892, American engineer Charles Brady King invented the pneumatic, I didn't say that right, hammer. In 1921, President Warren Harding signed the Emergency Quota Act, which established national quotas for immigrants. In 1926, NBC found RCA. In 1928, 51 frogs entered the first annual frog jumping contest. I had to include that. In 1944, writer and civil rights activist W.E.B. Du Bois became the first black member of the American Academy of Arts and Letters. And this, I'm sure all of you remember. In 1964, the U.S. diplomats found at least 40 microscopes planted in the embassy in, I don't think that's right. Thank you. Thank you. In 2018, and we all watched it, American actress Meghan Markle married Prince Henry in a ceremony in Windsor Castle. And today is the birthday of the activist Malcolm X. And now it's my pleasure to turn the mic over to Judy Beck, who will introduce our fabulous speaker. Come along, Judy. I'm done.
Thank you very much. It is my pleasure to introduce my friend, co-member of the club, and ombudsman, who scolds me regularly because I deserve it. I have a tendency to hug everybody I know, so that's illegal, and Roger has to scold me. Roger, excuse me. Roger was raised in Miami Beach and graduated from Norland High School. He went on to attend Florida State University, where he majored in finance and minored in American history. Following his undergraduate studies, he entered the U.S. Air Force, where he became a military policeman. So behave yourself or he will arrest you. After completing his military service, Roger earned his law degree from the University of Florida School of Law, then moved to Orlando. He just told me he came to Orlando when he was in the Air Force and he was stationed at McCoy. So he was already in Orlando and then he came back. He received his law degree and he practiced here for 23 years before being elected as a circuit court judge. He served on the bench for 18 years, completing this writing is very small, completing 3 full terms before retiring from full-time service, and he is now a part-time judge, and you can watch him on your computer, and he will be glad to provide that information, I'm sure. Roger, or Your Honor, welcome. That's illegal.
Welcome, everybody. Before I begin, I want to thank my wife, Sue, a retired high school English teacher who was my editor and who made valuable improvements to this talk. Also, Sherry Levy and Ovid Vitus, who encouraged me to give this talk. Sharon Vitus, also to be thanked for her wonderful poster, and our facilities manager, Manuel Suri, for his audio-visual help in setting up the equipment and setting up the room. Lastly, I want to thank all of you for your interest in the subject of presidential immunity. Without you, there would be no talk. This talk is about providing you with the information that you need to better understand what you hear in the media and for you to have a more informed opinion.
The Honorable the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh yay, oh yay, oh yay. All persons having business before the Honorable the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Trump versus U.S. is the 2024 Supreme Court ruling defining the scope of presidential power and its immunity. As you know, when the Supreme Court issues a ruling, it becomes the law of the land, equal to the laws passed by Congress. For our country, this case is historic and significant. That is why I researched and wrote this talk. Historian David McCullough wrote that the study of history is the only way to truly understand the present. Therefore, I will begin with the history of immunity. Immunity began in the Middle Ages, when kings ruled with absolute power. They were above the law and could do no wrong. This British idea originated from the divine right of kings, which held that monarchs derived their authority from God and were accountable only to God. Legally, this concept was known as sovereign immunity, with sovereign referring to the king. With the rise of democracies and the creation of parliaments and congresses, sovereign immunity changed to be government immunity. This principle protects all government workers from legal actions, civil or criminal, when they are performing their official duties. Today, our country and many other countries, such as the United Kingdom, Canada, Australia, France, Germany, Japan, China, India, just to name a few, have some form of immunity for government workers during and after their public service. On a personal level, I am a retired circuit judge, and I continue to serve part-time. Then and now, judicial immunity protects me from civil lawsuits and criminal prosecution for decisions which I made in my legal capacity. In every lawsuit, in every case, there are winners and losers. To the winners, I'm a brilliant, learned judge. To the losers, I'm an idiot. Without immunity, few people would be willing to risk their personal assets and freedom to serve as a judge, a police officer, or other public official who has to make difficult, dangerous, and often controversial decisions, all in the public interest. In 2024, the Department of Justice presented facts to a grand jury of 24 citizens, and they determined that there was sufficient evidence of criminal conduct to charge Mr. Trump with 44 felonies for his questionable acts during and after his presidency. The U.S. Attorney often then takes the U.S. Attorney's Office then takes an indictment, arrests the defendant, and prosecutes the case. This is why Mr. Trump was arrested. His attorneys filed a motion to dismiss all charges, arguing that a sitting or former president is entitled to absolute immunity for any and all actions directly or indirectly related to the presidency or thereafter. In America, sovereign immunity for a president is called presidential immunity. It is not mentioned in the Constitution or any laws passed by Congress. Instead, presidential immunity and government immunity in general exists, and its scope is defined by the courts. Mr. Trump is the first president to face criminal charges, and therefore his case creates new law. The Supreme Court's 109-page opinion, including dissents, is divided into two sections. The first and most extensive section examines the history of presidential immunity and defines its scope as decided by 6 of the 9 justices. Now, please remember that fact, 6 of the 9 justices. This is the section that I will explain. The second section, a shorter section, briefly discusses a few of Mr. Trump's actions, but leaves the determination of criminality to a future court. I want to take a few minutes to explain how the Supreme Court makes its decisions. All the justices discuss the issues in the case and then vote. The opinion is written by one of the justices in the majority. Court opinions are written by tracing the history of the issues, then reviewing the legal precedents, and finally explaining the history's current ruling. This process ensures that both the public and private parties understand the court's reasoning and decision. My favorite Supreme Court justice is Earl Warren. He had a court rule to not make a landmark decision, meaning a decision that marks a turning point in the law, unless there was unanimous or near unanimous agreement of the justices. This rule helped eliminate partisan viewpoints and ensure a more balanced and impartial judicial decision. The leadership of Justice Warren contrasts sharply from that of the current Chief Justice, John Roberts. Under Justice Roberts' leadership, landmark decisions are decided not by consensus, but by simple majority of justices, 5 out of 9. Chief Justice Roberts has faced widespread criticism from attorneys, legal scholars, and political commentators for permitting a bare majority of 5 to overturn long-standing legal precedents and to decide current issues with interpretations widely seen as partisan. In Trump versus U.S., Chief Justice Roberts even acknowledged what I just said. Quote, Supreme Court rulings are determined by majority rule, even if the margin of justices is narrow. Justices in the minority of this court and many legal scholars do not agree with our decisions. Remember, and he said this very adamantly, it's the majority that controls. Well, that's his rule. I have always believed in consensus because none of us are absolutely correct. It is the judgment of all of us together that makes a better decision. But I, along with many others, believe consensus decisions like Earl Warren used to create a more thoughtful analysis of what the law should be and to eliminate the appearance of partisan politics under Justice Roberts' leadership, respect for the Supreme Court in the legal community and in the public is at an all-time low. A good example of how Justice Warren's consensus rulings worked is the landmark case of Brown versus Board of Education. That decision had all 9 justices agreeing to the correctness of the opinion. Unanimous opinions give a landmark case more respect in the legal community and broader support for the public. Chief Justice Warren delivered the court's opinion, which declared that racial segregation in public schools to be unconstitutional because it violated equal protection. The mythology back in the late 1800s was, well, if we have black schools and white schools, they will be equal. But that just was false because they were never funded. The black schools were not funded, and all the money went to the white schools. And so the theory and the practice did not work out. Brown versus Board of Education was necessary because when the Constitution was written in 1787, slavery and many other forms of prejudice were socially acceptable to our founding fathers and was legal. This bigotry was further entrenched in the American law when the Supreme Court in 1896 decided Plessy versus Ferguson. That's another case you should be aware of. This ruling endorsed the right of states to enact and enforce separate but equal laws promoting racial segregation and other forms of racial and religious discrimination within their borders. So essentially, after the Constitution was, basically after the Constitution, and probably for 100 years, we had what's called states' rights. And so the Supreme Court and the government, federal government, deferred to the states. You could do anything you wanted if it was under the guise of states' rights. And the Supreme Court made that the law with Plessy versus Ferguson. The Constitution is a brief document, just a few pages. It was not written by saints or handed down like the Ten Commandments, but by 55 men, politicians, lawyers, slaveholders, and businessmen sent to Philadelphia to represent their states. The Constitution was the product of intense debate, hard bargaining, and compromise. It is mostly written in broad principles rather than detailed plan of government operation. An amendment process was provided in the Constitution since they knew that over time the Constitution would need to be amended to meet the changing needs of a modern society. The terms of the Constitution represented the best compromise and consensus that could be reached at that time and place. Many people in England believed that the American experiment in self-government would soon fall apart and fail. In the Trump case, Justice Roberts discussed the 1803 Supreme Court case of Marbury versus Madison. If you are interested in this subject, you should know Marbury versus Madison. The president in 1803 was Thomas Jefferson. Mr. Jefferson ordered his Secretary of State, James Madison, to not give Mr. Marbury his appointment as a judge in the D.C. court. And that was done for partisan reasons. Jefferson wasn't as saintly as he's made out to be. That is, the outgoing president, John Adams, made last-minute appointments of his supporters to various vacant offices in the government, and then left the signed appointments on the Secretary of State's desk to be delivered by Mr. Madison, the new Secretary of State. Mr. Adams then went back to Massachusetts. Mr. Jefferson ordered Mr. Madison to not distribute them because Jefferson wanted to appoint his political followers to those same offices. The Marbury versus Madison case stands for several important legal principles, but its relevance to immunity is that it used for the first time the term official acts. That's a key word for you to remember, official acts. As far as the president goes, the term that is politically and legally used still today. Justice Marshall in Marbury versus Madison used that case to elaborate and clarify the meaning of executive power. Article 2 of the Constitution defines the duties of the presidency of the United States. Its introductory sentence is very simple. The executive power shall be vested in a president of the United States of America. That's it. Justice Marshall was the perfect person to write about executive power. He lived during the creation of the Constitution, and he knew most of the delegates who negotiated the Constitution. Justice Marshall understood the purpose and meaning of the terms of the Constitution. He explained that when the president makes a decision and gives directions to the agencies, it is called official acts. A common criticism of both Marbury versus Madison and Trump versus U.S. is neither case outlines a clear method for restraining a president who becomes unchecked. The only remedies suggested are impeachment and waiting for the next election. Neither are very expeditious or effective, as we all have seen. That's my computer. I'm the guilty party. Justice Marshall explained in 1803, and it is still used today, that official acts are two types, discretionary and ministerial. So you should have in your brain official acts, and then come down discretionary and ministerial. That covers everything. And let's begin by understanding discretionary acts. And I think this is really what concerns so many of us today. And it does hold the answer to perhaps the reason you came here today. Discretionary acts refers to decisions and policy directives by a president based on their personal judgment and political party priorities. In these areas, the president cannot be micromanaged by the courts. The president only answers to the voters. That is, even discretionary powers have limits, though. The president must operate within the boundaries of the law. But as long as the discretionary acts do not violate a law, the courts cannot overrule a president's discretionary decisions. When Congress writes legislation, Congress is responsible for clearly defining the law's scope and establishing the limits of the agency and presidential, and the agency and the president's power are outlined. But Congress cannot anticipate every bad act or actor. So good faith and reasonable judgment are implied in every law. Justice Roberts wrote, please listen, because I think this is key to this whole decision. So the law to have the Department of Education. So we have a law that establishes the department. When a law provides little or no guidance or constraints, the president is largely free to act according to their own judgment. In such cases, those who disagree with how that discretion is exercised have no legal recourse. as courts are tasked with enforcing the law, not dictating how the president should exercise their discretionary acts or authority. Recourse is with Congress. If Congress would, but when Congress is controlled by the president, it's almost a farce. Or the next election, which is really the only thing that can return us to a more democratic government. My friends, and clearly you should understand that it's really the next election that's going to change things. The court is saying that they don't have the power to say that's a stupid decision. The courts just don't do that. And we don't want them to do that anyway. Discretionary acts discretionary acts encompass the broadest scope of presidential decisions. In 1803, Chief Justice Marshall wrote, and it is still the law today, the president is invested by the Constitution with certain important political powers in the exercise of which he is and can use his own discretion and is accountable only to the country. And when Justice Marshall said that, when he said country, he really means the voters. As I have said, discretionary acts involve the use of personal judgment, values, policy beliefs, political viewpoints, and the need to satisfy the president's political supporters. That's really all the president is concerned with. Everyone else. Chief Justice Marshall wrote in 1803 that discretionary acts are only politically examinable. This clearly means that it is the voters and only the voters to whom the president is accountable. Trump versus U.S. implies that much of what Mr. Trump is doing, whether it's popular or not, is his right to do. Only the voters can determine whether a president's discretionary acts and decisions are good or bad at the next election. However, the Constitution gives the people, and I quote, free speech and the right of the people to peacefully assemble and petition the government for a redress of grievances. It seems to me that the thousands of peaceful protests nationwide are the expression of the opinion, or opposition, or support that is all that can be done, and that is all that can be done until the next election. Today, Justice Roberts is following in the footsteps of John Marshall when Roberts wrote in the Trump case, the president was elected to exercise his personal judgment and implement the policies of his party, whether the Supreme Court likes it or not. The point Justice Marshall in 1803 and Justice Roberts in 2024 is best understood by an analogy which I heard Justice Stephen Breyer make several years ago. And I think this it helped me understand it, even though I've been a lawyer and judge for many years. Justice Breyer explained that an architect draws the plans, designs the home, defines the rooms where the doors and the windows will be located. The Constitution is the plans for the American home. However, the architect does not decorate the home. It is Congress and the President who are elected to decorate the home by their laws. They can pick the curtains, furniture, and paint the walls as they deem appropriate after every election. That is, each Congress can amend, do away with any law that a prior Congress passed, because that is what is democracy is all about, and it does not violate the Constitution if they want to change things with their election. That's the role of the courts is like the building inspector who makes sure the house is built according to the plans, which means the Constitution. And over the years, the inspector will make sure that the various occupants do not create an illegal condition, such as a fire hazard, or modify the house without a building permit. It is not the job of the courts to order new curtains or to arrange the furniture. That is the job of elected representatives. And I really think the public has forgotten how important elections are. After reading Trump versus U.S., it is obvious that the Supreme Court and lower federal courts will not overrule a president's proper discretion, even if the acts are unpopular with many people, provided it does not violate the laws of Congress or court interpretations of the Constitution. In Trump versus U.S., the Supreme Court ruled that discretionary acts have conditional immunity. So long as the president is exercising his discretionary acts, in other words, he can get away with whatever he wants, he has immunity, and no one can do anything about it. Presidential immunity applies only to the actions taken in the course of official acts. If an act falls outside of official, the president can be personally sued or prosecuted. Whether a particular act qualifies as official is a threshold question for every case against the president. So the first question is this an official act or something that isn't? And if it's an official act, is there any prohibition? And if there isn't, he can do it. Justice Roberts wrote that one of the tools that modern presidents use to publish and carry out discretionary acts are executive orders. Only the president can issue them. These are not laws, and they cannot violate the law. Determining whether or not executive orders violate the law is a common type of lawsuit against the president. Executive orders are directives by a president to the government agencies outlining the president's policies. The agency is then to implement them. All modern presidents use executive orders. It will be interesting to see if the Supreme Court will hold Mr. Trump's executive orders to the same strict constitutional standard it applied to Mr. Biden. Example, the Supreme Court said that Mr. Biden's forgiveness of $60 million of student loans was a congressional function, not a discretionary act of a president. Executive orders are only in force while the president who issued them is in office. The next president can revoke or change them, as we have all seen. Justice Roberts writes extensively about executive orders. He says that both Republicans and Democratic presidents have increasingly turned to executive orders, reflecting a view that Congress has shrunk. Now, increasingly turned to executive orders, reflecting a view that Congress has shrunk by squabbling factions, paralyzed partisan gridlock, and is unable to pass critical legislation. For example, immigration reform has stalled for over 20 years without meaningful action. That has contributed to a crisis at the border and inside this country, all because Congress will not do their job. Mr. Trump has issued, since he took office, 151 executive orders. Mr. Biden, in 4 years, issued 162. Executive orders have become necessary because Congress does not pass clear, detailed laws, but instead they pass ambiguous, aspirational, goal-oriented laws like clean air that leaves the details to the president. Federal agencies to interpret and implement these ambiguous laws. In the last few years, the Supreme Court has begun to strike down agency regulations, which we all would probably agree with, because they violate the Constitution's separation of powers. In other words, agencies, when they're creating regulations, can't be creating laws. There has to be a foundation. So what comes first is law, that you can do this legally, because that's what democracy is about, the Congress, and then agencies implement the law. So if there's no law there, they just can't go off and do their own thing. The Supreme Court has ruled that the agencies are creating legislation, and that violates the separation of powers. So there's the separation of powers. Remember, we have the Congress, we have the executive, and we have the judiciary, and that's what's called separation of powers. And so they're saying the agencies cannot be passing laws because laws are what the Congress is supposed to do, meaning it's the responsibility of Congress to pass detailed and clear laws. In effect, the Supreme Court over the last few years has been, by striking agency rules, has been telling Congress, do your job. And the Supreme Court is getting angrier and angrier because these constantly come up, that Congress is not doing their job. Presidents, Republican and Democrat, knowingly issue illegal orders. The reason are that the president wants to appear to be doing something or to placate their followers with pretend action. Example, Mr. Trump recently issued an executive order making English an official language of America, even though he knows that only Congress can do that. Illegal executive orders remain in force until someone takes the president to federal court. As an aside, it is our system, as an aside, in our system of laws, courts do not file suit to correct a wrong or investigate illegalities as they do in certain states, countries. Lawsuits are filed by people who have standing. Suing the government is the proper and right thing for people to do because it is the way people, litigants, you and I, the people out there, lawsuits against the government is the people's part of checks and balance. As of a few days ago, there were 348 lawsuits filed against Mr. Trump. 348 alleging illegal actions by his administration and agencies. And remember, this is just it's almost 100 cases a month. It's only been 4 months. Remember, lawsuits against now this is really important because some people complain about, lawsuits. Remember, lawsuits against the president is how a democracy keeps the government in line and is an alternative to the violence and revolt. The modern phrase that best describes discretionary acts. Now, I would like you to do something for me. I want you to yell at the top of your lungs, and I want you to repeat after me. Go ahead. Elections have consequences. A little drama there. With our review of discretionary acts now complete, let's now turn to the other class of official acts. Remember, in your mind, you have official acts, and then a subcategory, discretionary, subcategory, ministerial acts. Let's now turn to the other one, discretionary acts, which is Article 2, Section 3 of the Constitution, directs the President as follows. He, the President, shall take care that the laws be faithfully executed. Laws fall into two categories: statutes passed by Congress and court orders and decisions. The President and their administration must both enforce the law as to others and abide by the law themselves. You can't have a government enforcing laws against people who are lawless themselves. That is what is the rule of law is. Now, in 1803, Justice Marshall created the term ministerial acts. So these labels go back to 1803, Marbury versus Madison. This ambiguous constitutional phrase, faithfully executed, means that the President is constitutionally obligated to enforce the laws passed by Congress everywhere in America and the rulings of the courts fully, honestly, without bias, prejudice, or manipulation. The word shall means mandatory. It does not give the President the power to ignore, selectively enforce, or interpret the laws based on the president's personal preferences or political goals. I thought it was a violation of this provision when Trump said that he wasn't going to enforce the bribery laws. That, in other words, we have a law in America that says American businesses are not allowed to bribe foreign governments. We're not allowed to do that. And many other countries do that as a policy. But Trump has said that law he was going to ignore, and that the U.S. attorney should not file any lawsuits and should by deference, allow American businesses to bribe foreign governments in order to get contracts and business. So Trump can't do that. There's a law that says you cannot bribe foreign governments, and he's chosen to ignore it. And I'm sure that's one of the 346 lawsuits that are out there. I refer you to the good example, talking about complying with the law. I refer you to the good example of Brown versus Board of Education and President Eisenhower. President Eisenhower is one of my favorite presidents. He did what a good president should do, appointed the very best people, and then he went and played golf. On the other hand, a very bad example is the troubling and bad example of President Andrew Jackson. He refused to enforce the Supreme Court's ruling as to Indian land ownership. And so let me give you the backstory. In parts of Georgia, Native American tribes had lived there for centuries, if not thousands of years. And they held legal title to their land through various treaties. But when gold was discovered in Georgia, President Jackson began arresting, evicting, and forcibly removing the Indians from their land. The tribes took President Jackson to court, and the U.S. Supreme Court ruled in their favor and affirming that the Indian had ownership and property rights like every other person in Georgia. But Mr. Jackson ignored the court's ruling and legally and illegally arrested and marched the Native Americans out of Georgia on the Trail of Tears. He then allowed his supporters and investors to take over the Indian lands. The tribes and court, the Supreme Court back then, had no way of making Jackson follow the law. And this injustice remains a dark stain on our nation's history. We have now finished with official acts. So official acts, discretionary, which is what mostly a president, Mr. Trump, can do, and then ministerial must follow the law. So close that chapter in your mind. And I want to make a distinction here between personal acts and official acts. My hoarseness is more of an allergy issue than illness. Personal acts are when a government official is acting as a government agent. So they're acting like as if they were the government, but on a frolic of their own. That's actually a phrase from a case, but I don't remember what case. personal acts have no immunity, and the perpetrator can be sued or arrested. Examples are abuse of power by using the IRS, FBI, or Justice Department to harass or intimidate critics for retribution against enemies, targeting the media, colleges, or other politicians, like Mr. Nixon did. Mr. Trump seems to also be going down that same route. There was also financial corruption of Vice President Spiro Agnew, who was accepting bribes in the White House. President Harding was accepting bribes in the White House, and the history is, do you remember in history, that was called the Teapot Dome scandal. See, Teapot Dome was a park, and these contractors wanted the contracts to be able to do things in the parks, so they started bribing President Harding. So corruption is, we can't have this false sense of, oh, America is so great. No, we've had plenty of corruption in our country, and it's up to us to push back on it. Another example is Bill Clinton, who had sexual relations with various women before and during his presidency, and lied under oath about it. One of the women, Paula Jones, sued him while he was president for sexual harassment while he was the governor of Arkansas, and he settled by paying her $850,000. What an idiot. I lost a lot of respect for him for a number of reasons. The Supreme Court said his personal actions had nothing to do. See, he said, well, I'm president. I can't be sued. And so that went to the Supreme Court. And the Supreme Court said his personal acts had nothing to do with his job. And Justice Roberts added, no person has immunity from personal civil suits, even when president. And Justice Roberts wrote, personal acts of a president that are alleged to be illegal or wrong before, during, or after office are just like that of any other person. The president enjoys no immunity for his unofficial acts, and not everything a president does is official, and the president is not above the law. Justice Roberts, in the Trump case, wrote, Justice Roberts in the Trump case wrote an interesting example of official acts versus personal acts. And this is his example, not mine. If the president orders a person assassinated, and there is proof that the person was a terrorist, immunity applies, and there is no crime. If the person is shown to be just a political opponent, immunity does not apply, and a president can be arrested and prosecuted for murder because it is a personal act. Mr. Trump, like Mr. Nixon, has his enemies list. And recently, Mr. Trump directed the FBI and federal prosecutors to begin investigating and prosecuting his enemies. I suggest that this is a personal act, not an official act, for which there is no immunity, and he can be arrested when there's a Democratic administration. To know history is to be forewarned. Justice Roberts spent considerable time discussing the importance of separation of powers. He wrote that our founding fathers deeply feared concentrated power, and having witnessed kings and aristocrats all ruling with unchecked authority, to prevent this, to safeguard us, the founding fathers designed a system of separation of powers so that no one branch of government has too much power and each has checks and balances of the other. At least that was the theory. For nearly 250 years, the United States system of separation of powers and checks and balances has protected this country from tyranny. We all hope that it will continue to do so. In Trump versus U.S., Justice Roberts discussed a category of exclusive presidential actions referred to as constitutional core acts, or simply core acts. These are not official acts. Something I didn't realize. So, every time you do research for a talk, you learn things you think you know, but either correcting or expanding what you do know. Official acts are over here, and we now know what official acts are. And then over here is a whole thing I didn't realize, which is called core acts, and core acts have absolute immunity. Almost done. In Trump versus U.S., Justice Roberts discussed the category of core acts, and these are the acts of the president. And this Article 2, Section 2. And as you see, the president can grant reprieves or pardons and recognize foreign countries, remove administrators, and all of this is his total discretion. He cannot be questioned about it. And Chief Justice Roberts and the 5 justices who align with him appear to follow the doctrine known as unitary executive. It is an authoritarian interpretation of the constitutional term executive power. And so this is something you really need to be aware of and understand, unitary executive. I just heard it the other day on the radio about a unitary executive. So it's being pushed by sort of right-wing groups and everything. It is an authoritarian interpretation of the constitutional term executive power. It advocates for virtually unchecked total authority of a single executive. Advocates for this theory argue that the president, as chief executive under the Constitution, should have total control of the entire government, even rejecting legitimacy of independent agencies. There should be nothing independent because the unitary executive is the boss. Their political theory places all government functions under the direct control of a single executive with minimum oversight by Congress or the courts. It diminishes the role of Congress and maximizes the role of the president. Unitary executives even question the right, or the obligation, of the president to follow court orders. They feel that the president should be above everything, like the dictator of our country. Unitary executives advocate to eliminate civil service because they argue that civil service interferes with the president's exclusive power to run the government. The president should have the right to fire and hire everybody he wants. Their argument is that a new president should not be burdened by government workers who might have some loyalty to a prior president. They want also the ability to have patronage. Patronage. So the whole thing about getting rid of civil service is so you can fire a lot of people and hire all of your people. And so it's patronage. Patronage is distributing government jobs, contracts, and other benefits to individuals as a reward for their political support or loyalty to the leader, regardless of their qualifications. This practice would return America to the spoils system, remember? And that corruption we all went through historically was the late 1800s. I point this out because historically we have already had this argument. The idea of a powerful one-man executive was rejected by the Constitution. At the Constitution, Alexander Hamilton and others advocated for a strong executive. On the other side of the argument was Benjamin Franklin, who feared and worried that a powerful single leader would lead to monarchy, or what we call dictatorship today. The Founding Fathers ultimately compromised. Well, okay, we'll have a strong executive, but we're going to have these separation of powers and checks and balances. The famous historian Arthur Schlesinger Jr. wrote an article that I believe summarized the issues we are all facing today. In 1970, Mr. Schlesinger wrote about his concern of a growing and out-of-control presidency, which he called the imperial presidency. This was his way of expressing fear of uncontrolled growth and power of the office of president. This was 1970. Since then, presidential power has expanded under both political parties, and Congress's power has steadily waned. Mr. Schlesinger stated that Founding Father system of checks and balances has seriously eroded, and the presidency is now dominating or controlling Congress, rather than Congress serving as a check and balance of the president. If he were today, he would be both alarmed and disheartened by Congress's weakened power and by a presidency nearly unchecked. I recommend that you go to YouTube and watch Senator Rand Paul, R-A-N-D, Rand Paul, give a recent speech on the Senate floor called Cowardice of Congress, where he agrees with Mr. Schlesinger. I will close with two thoughts. First, Trump versus U.S. is widely criticized for granting broad presidential immunity with no clear safeguard to protect the rule of law. Chief Justice Roberts seems entirely focused on granting the president more and more power, but he writes very little about the president's duty to follow the law. Over the next 4 years, Supreme Court cases will tell us if we have strayed from the Constitution's original design of balance of powers. I and many others are gravely concerned about the course of our country. Finally, I fervently hope that a future Supreme Court will return to consensus rulings, near unanimous decisions, which I believe is essential for a nonpartisan, well-reasoned opinions of the court. Thank you.
I can't run around with the mics, so I understand, and we've run so late. All right, questions from the audience? And the two runners. There's a question over there. I'll let you in charge of that.
Thank you very much, Roger. That was very enlightening. My question is about the minority in the immunity case. What was their position, and what is the contrast between majority and minority in that case?
Well, the minority says that that there really should be more obligation to follow the law, and that he shouldn't have very broad discretion. The original design was you should administer the law, not destroy the so like the Department of Education is the easiest one. So Trump has reduced it by 99%, and that should be illegal. And so, but the way it's written, the court seems to say, well, he's the president, he can do that. And and the minority says he really shouldn't be able to substantially change the law. For instance, like the Department of Education, he shouldn't be able to fire 90% of the people. And so he only technically kept 1%. And so I'm not violating the law. The agency still exists.
You said that one of the three main authorities of the president was to uphold the Supreme Court ruling. What happens if a president doesn't uphold the Supreme Court ruling that may say that the president violated the existing law?
That's a good question that everybody's concerned about. Just like Andrew Jackson just said to the Supreme Court, screw you, I'm going to do what I want, and arrested all the Indians and drove them out of Georgia. The Supreme Court has no army, no police, and so really they could request Congress to file charges of impeachment or to correct a law to make something illegal. But frankly, there's nothing the court can do. Now, I've held people, for instance, like when I was doing domestic relations, every Friday I did child support, and I put people in jail. But the only way I could put people in jail is if I gave them a purge amount. So I would say, sir, I think you can pay $500, or your girlfriend can, but you're behind in your child support, and without a good reason. So I put people in jail, but you have to give them the keys. So really, the court system, other than putting people in jail as a way to make someone follow the law, we really don't have many tools to use. So there's really no way of doing it.